It was the night before the retrial, and all through the courthouse, not a creature was stirring. Well, everyone is stirring. Everyone is ready. Tomorrow is the day. This is not a joke. April 1st, the retrial of the century, Karen Read. But today, major rulings by Judge Cannoni, one of which is really the headliner of headliners when you talk about rulings, and it's what this case has really become all about. We are going to talk about it right here on this live stream. I'm Vinnie Politan, lead anchor for Court TV. I'm on television every night from 8 to 10, talking about this case and all the other big true crime stories around the nation. But right now, folks, we are streaming, and this is Vinnie Live.
Hey, get ready, get set, let's go.
It's true crime, streaming live, worldwide. It's Vinnie Live. It's true crime, streaming live, worldwide. It's Vinnie Live. Get ready. So post inside the chat. Get ready for the prosecutor hat. Get set to like and to subscribe. Let's go. It's time for Vinnie Live.
Let's go. Are you ready? Are you ready? It's the retrial of the century. This is a big one. This is a big one. Rarely is the retrial more compelling than the first trial, but this one will be. Karen Read accused in the death of her boyfriend, John O'Keefe, Boston police officer, but they have a whole different version of what happened that night. Karen Read and her defense team, and that's why this case has taken on a life of its own and is different than every other one that we've covered through the years, because you have someone, Karen Read, who has garnered a lot of support locally and now a lot of support around the nation with all of the aftermath of the first trial. First time around, yes, people were watching. People were watching. We track that at Court TV. We know how many people are watching. But there wasn't as much cross chatter about the case. And when I say cross chatter, it's about people outside of our world of true crime and trials and justice talking about the case. But now they are talking about this one. It was the same thing with Alec Murdaugh. It was one of those cases that crossed over to the what I call Gen Pop of society, the general population, the civilians, the ones who aren't obsessed with true crime like you and I. But they are there. They are invested in this story. Everyone's wondering what's going to happen. So today, a major rule. Let me get right to it because I don't want to run out of time. I don't want to run out of time, and I want to get to a lot of your comments today. I know people feel very passionately about this story and about this case. Streaming live on my Facebook channel, on my YouTube channel. I am streaming live on X, on Twitch, and welcome to all the folks watching on YouTube's, on Court TV's YouTube channel as well. Welcome to all of you. Great to have you aboard this afternoon. So then when you get a ruling from the court, I'll give you a little trick, a little insight. A lot of you probably already know it, though. When you get an opinion written by a judge, you know, sometimes it can be 1 page, it can be 40 pages. I always go to the last page to find out what the actual ruling is and what the judge is ordering. I read that first, so I have some sort of framework for reading the rest of what the judge found, you know, in their statement of facts, in their application of the law to the facts, the conclusions they're making. But I want to get to the order and the ruling, which is at the end. So let me put that up for you right here, right now. I'll make it large. Don't worry. Here we go. And this is not a win for Karen Read, but it's not panic time for the defense. This is, I think, relatively similar to what we had in the first case. It is hereby ordered that the defendant is precluded from raising a third-party culprit defense alleging Colin Albert is culpable for John O'Keefe's death. The Commonwealth's motion is allowed as to Colin Albert. Okay, that's important. Colin Albert's the teenager, the young guy, had the we saw a picture with some scrapes or bruising or whatever you want to call it on his knuckles. He took the stand, said he never fought. There was a video of him fighting. Was there bad blood between him and John O'Keefe? They were used to be neighbors. All of that has been raised. But the judge has ordered that the defense cannot point the finger at Colin Albert. Prohibited, precluded. Okay? That's a loss. That's a loss because everything that I've heard in terms of from the community and from the lawyers in court is that they believe he was there and they believe that he was part of what happened to John O'Keefe. But they will be precluded from that. Now, this is the second part of the ruling. This is where there's not a complete loss for Karen Reed. The defendant is not prohibited. That's like a double negative, right? Why do we do that? Like, why do we throw a double negative in there? The defendant is not prohibited, which means the defendant is allowed to raise a third-party culprit defense as to Brian Albert and Brian Higgins at this time. Counsel, well, I guess what she's saying is, I'm not ruling it out, but there are some conditions here. Counsel cannot mention potential third-party culprits in opening statements. But, and this is a big but, this is a huge but, enormous but will be given the opportunity to develop the theory through relevant, competent evidence at trial. The Commonwealth's motion is denied. Okay, Commonwealth's motion is denied as to Brian Albert and Brian Higgins. So the two Brians, Albert and Higgins, the butt dialers, the phone destroyers, the shadow boxers inside of the Waterfall Bar and Grill, they just need to develop relevant, competent evidence. Now, that doesn't mean that they're in the clear. They've got to get the evidence in front of the jury, and it's got to be enough to convince Judge Cannoni that they can point the finger directly at Albert and Higgins. Now, in the second trial, I think they'll have a little more behavior and conduct by Higgins with some additional videos that they received and another phone call that he is seen making. So, or seen on the phone, at least on video. I haven't seen the video yet. So this is, it's a split here. So Colin Albert out, the teenager, but Brian Albert potentially in, Brian Higgins potentially in, right? They are not prohibited, but not, it'll be permissible. It will be allowed if they develop the theory through relevant, competent evidence at trial. Now, this is a little quirk in our system of justice that's a little problematic, okay? Especially in a case like this. And the reason this is a disadvantage for the defense is that part of what they're alleging and part of the facts of the case are that there was no investigation of Albert and Higgins at the time. So you look at this from the defense perspective, from Karen Reed's perspective, the best evidence in this case for them was not gathered by investigators, right? They didn't go into the house. There was no investigation of the house itself. And because there was not any investigation of the house, the defense believes that evidence was lost. It's evidence they did not have an opportunity to get. So the reason it is often very difficult, and I said this was one of the reasons I did not believe that they were able to prove third party in the first trial, was because of the investigation. Third parties were never investigated. Like, it's hard to prove something against someone if they were never investigated at the time that all this happened. So it's like a catch-22 for the defense. And it's a little quirk and it's a little problem. And it becomes a bigger problem because of the way this judge is going to hold their feet to the fire on whether or not they can make arguments even against Albert and Higgins. In other courtrooms around the country, because we cover trials all over the place, I've seen a lot less evidence and people having the finger pointed at them with a lot less evidence than here. And that's different states, different judges, different jurisdictions, different rules, different interpretations, etc. But I've seen in other cases in other states where the defense has pointed the finger at someone with a lot less evidence than exists in this case. But they may not be able to even do it in this case unless they develop enough relevant, competent evidence in the eyes of Judge Cannoni. It's a big deal. It's a big deal. But the inherent disadvantage and problem, and which is why I believe a lot of other jurisdictions allow it with a lot less evidence developed, is because the defense is at a disadvantage because of the way the initial crime is investigated, right? If they got blinders on and they're just focused on the front lawn, they don't go in the house, all that evidence is gone. So the defense has no chance to develop that. They basically have to make their case over sort of the leftovers from the prosecution case and then try to develop more if they can. And here, where they had help was from the federal investigation. The grand jury that was investigating the investigators uncovered the phones, uncovered a lot more evidence in the case, including developing some expert testimony that really handed the defense their defense. Like, that federal investigation doesn't take place. This is a much different trial. Oh my goodness. It's a much different, because the defense never gets their hands on any of this stuff. So some of the most compelling defense evidence in the first trial without the federal investigation does not exist. Because again, they're relying upon what is being done by the state investigators, and then the feds came in, and thank goodness they did for Karen Reed, because if they didn't, it's things are going to look and sound a lot different inside the courtroom. So here we go. So let me get into now some of the specifics. Let's get first Colin Albert, why the judge ruled the way she did. As to Colin Albert, the defendant's proffer contains no additional evidence than that presented at the first trial, and it is insufficient to support a preliminary finding that Colin Albert had the motive, intent, and opportunity to commit the crime. She begins with, the evidence of opportunity is wholly inadequate. There is no evidence that Colin Albert was at 34 Fairview when the defendant, Mr. O'Keefe, arrived at home. Okay, and then they cite a case, third-party culprit evidence, properly excluded, where there was no evidence the third party had means or opportunity to commit crime, and evidence of motive was speculative and too remote. She says evidence of the first trial was that Colin Albert had already been picked up by the time O'Keefe and the defendant arrived at 34 Fairview. I think that is a point of contention. I think that is a point of interpretation of evidence. But it's the ruling by the judge, so they're stuck with it. Because I think this part of the evidence was one of the most confusing parts of the case, was to figure out exactly who was where, when, and where they parked. And when they left, there was a lot of gray area in that. So I don't know why the judge is so convinced that the evidence at the first trial, like, it wasn't uncontroverted evidence. There were a couple different interpretations of that evidence as to when exactly Colin Albert left. It was not definitive. There was some evidence to the contrary. So I think that's important. What's interesting, let me see. Like, you've got to determine exactly when Karen Reed and O'Keefe show up at the front door. Like, when exactly do they show up with their car, right? At what time is he leaving? There's some text messages back and forth. There's his testimony, but everything was a little just a little vague for me for a definitive finding of fact by the judge here. But the judge did it, so they're stuck with it. All right, I want to put up the next part of the judge's ruling. I want to get through this off the top of the video so we can get to some of your comments, reactions, etc. There we go. Image. All right. I think I'm here. As to motive, the defendant contends that Colin Albert had been in a feud with John O'Keefe in the weeks and months leading up to O'Keefe's death, and that Colin Albert had thrown beer cans on O'Keefe's lawn and swore at him. There was, however, no evidence substantiating these claims at the first trial. Then there's a footnote. And here's the footnote. Read the footnotes. I always read the footnotes. I had a thing where I would always include footnotes, and I would put something in there that would always be interesting. Let's see what it says. To the extent that at the upcoming trial, the defendant would offer hearsay testimony to support the claim that Colin Albert had a feud with O'Keefe to be admissible, such evidence must be otherwise relevant, not tend to prejudice or confuse the jury, and there must be other substantial connecting links to the crime. The proposed evidence does not provide a substantial connecting link between Colin Albert and O'Keefe's death. See, this is like a little argument where the judge is covering herself, saying, look, an acknowledgement that there is some evidence to support the claim that there was a feud, but you'd have to offer hearsay and there must be other substantial connecting links. Now, she is quoting some case law here where she's getting the legal test, right? So the legal test for this to come in is there must be some substantial connecting links, but a substantial connecting link is not like black and white. That's, again, in the eyes of the beholder, and the beholder is the judge. So the judge, citing the proper law, right, and the proper test, but at the end of the day, the call on whether some hearsay comes in as an exception is a judgment call by the judge, as is determining what is a substantial connecting link. That is a judgment call by the judge. So all of this is in the hands of the judge. So while you can say it's not admissible or there is no evidence, a different judge could find that this was relevant and substantial and would allow it. This is not a black and white call on this evidence. This is one that is going through the filter of this particular judge, because there is room for interpretation of what is substantial. Is the hearsay admissible? The rules of hearsay are very convoluted and complicated. Try taking that class in law school. Your head will be spinning around and around and around and around. It's not simple. And a lot of times it comes down to, does the judge want it in or not? But what the judges do when they make decisions like this is they provide the reason she has a written opinion in all of this is to provide her backup for it based upon precedent. So she is citing these cases to support her opinion and her fact finding here. But she is doing some fact finding. And it's that fact finding of what is substantial and et cetera that allows her to draw the conclusion that may be very difficult on appeal to overturn, because the judge is using some level of her discretion as the trial judge who was able to see and hear the evidence and judge credibility, et cetera, and have the big picture in her mind. But make no mistake, like, this decision is not like black and white. It's not like every judge would not make the same call here. You could have another judge make a completely different call. And that's the nature of our system of justice, is that it's not scientific. It's not like super scientific, like right, wrong. Some things are obvious. A lot of the law is left in the discretion of judges. You know, the jury has the ultimate discretion, right? But the judge filters the things that the jury gets to hear. So those calls like this can impact the way a jury hears the case. I'm just trying to give a little more context to what's going on here in terms of outside of this case, because I know people, and you're all in the chat room right now, I know people are extremely passionate and have strong opinions about this and about all the players involved. But what I'm trying to do is put some perspective on it. And the perspective is that this particular decision by this judge is not one that is like, oh yeah, of course that's the decision. No, it could be very different in front of a different judge. So it is, in fact, while it's, I believe, will be legally sound on appeal if Karen Read is convicted, and that's a big if, it'll be legally sound because of the way the judge has written it and the way the judge has explained it. But another judge could write it and explain it and come to the exact opposite conclusion, and it would be just as valid. Okay? I think that's the best way for me to put it. That this is like a judgment call by a judge, which is what they get paid to do, but different judges could see it differently. And I don't think that makes the Karen Read supporters feel any better about this, but I just want everyone to understand where this particular legal ruling stands versus some of the other ones. All right, let's continue here. Oh, wait, I only got to the footnote. I got another sentence. Even if there was evidence of some ill will between O'Keefe and Colin Albert, motive alone is not enough to demonstrate third-party culpability. Right? We get it. Like, so this is another interesting argument, right? Motive alone is not enough. So if you don't have motive, you can't argue third-party culpability. But if you do have motive, you need more. Well, they're saying there's more, there's opportunity, but that has already been dismissed by the judge in the first part of her argument. So now she does that first to eliminate opportunity. Now it's just motive is alone. And even if we have it, that's not enough here. There's no opportunity. So just because someone has a motive, you can't point the finger at them. They need to have an opportunity as well. But that was eliminated in the first paragraph of her argument. Like I said, this is written in a way to withstand appellate scrutiny. See, for a trial judge, two things are important. One, clearing cases off your docket, right? I got to clear cases. That's how you get evaluated. You know, does the judge have a huge backlog, or is the judge doing his or her job in clearing cases, whether it's by plea bargain, civil settlement, or by trial? You're getting rid of cases, right? That's important. The other thing is they don't want anything coming back. They don't want it coming back. So when you make a ruling that's in an area that's like, okay, it's not black and white law, you need a sound written decision and opinion backed by the case law, and then also provides a logical argument. And that's what she's done here. She's not stupid, not even by a long shot. She knows exactly what she's doing. She knows how to craft an opinion. All right, let's get to, I've got more. Yes, I do. I think that was number 3. So we're going to go to number 4. Moreover, one of my favorite words, the theory that Colin Albert is a third-party culprit because he has, I got it blocked here, because he had scraped knuckles at some point after O'Keefe's death, had been seen in a video drunkenly taunting others with no connection to O'Keefe, and apparently was not named in police reports, is speculative at best. Okay, so now she is taking some of the evidence that the defense has and quantifying it, right? This is not consequential evidence. This is speculative at best. It may not even be speculative. It's like nothing. This evidence has no value, right? His knuckles have no value. You know, getting on the witness stand and saying he's never been in a fight and then having a video of him getting into a fight, no connection to O'Keefe. Well, it's connected to his testimony and apparently was not named in police reports, right? Well, not named in police reports is all part of the defense theory in the case, that evidence is being hidden and Karen Reed is being misled as to who was where when. Okay. And then they go through a couple of the supporting cases, Acevedo and Andrade, talking about gang members. Allowing such feeble third-party culprit evidence poses a risk. Now she's calling it not only speculative, it's feeble. Allowing such feeble third-party culprit evidence poses a risk, unfair prejudice to the Commonwealth and would only serve to confuse the jury. So she's using the language from the Silva Santiago case to describe the evidence the way she sees it in this case. Feeble third-party culprit evidence. So that is, feeble is like not even speculative. This is the worst of the worst. So the bottom line here, Colin Albert, they will not be able to point the finger at Colin Albert here. By the way, folks, we got a nice crowd on hand today, 2,700 watching on my Facebook, my YouTube, my Twitch, my X, and on the Court TV YouTube channel. Welcome to all you folks. Great to have you aboard. If you're watching on my YouTube, make sure you subscribe to the Court TV YouTube. You can also become a member over there. I have a great membership program with lots of perks over on the Court TV YouTube. And if you're watching on Court TV YouTube, make sure that you are subscribed to my YouTube channel as well. All right. I did this one. All right, let me get to the next one. We got through the feeble evidence. Let's get to the next one. And she's quoting another case, but she's really calling that evidence feeble. Let's see what this one is. Brian Albert and Brian Higgins. And I would say this is more important for the defense anyway. There's more there, right? It's Brian Albert's house, number one. He's friends with Brian Higgins, was with him all day. Brian Higgins was exchanging flirty texts, including a text that night, or tried to exchange a text that night with Karen Reed. So there's a there. Plus, you've got all the other things, the butt dials, the after-hours butt dials, and the now more evidence involving Higgins. So here's the judge's ruling as to Brian Albert and Brian Higgins. The defendant's proffer is barely sufficient. So she said, listen, it's sufficient, but you guys just, you eked in there. You just eked in there. Like you don't even have a videotape of them doing it. Like you eked in there is barely sufficient. And the history of the first trial casts doubt on the seriousness of the claim. However, to protect the defendant's right to a fair trial, here we go. Right now, what the judge is doing is creating a record and allowing this, or allowing them to pursue this, because if she didn't, the appellate court would have a field day with any conviction down the road. So this is one where she's cornered to a certain extent, like not allowing them to even proceed here in a case where the U.S. attorney didn't convene a grand jury on these investigators. Like, come on. There was a federal grand jury convened. So that's a lot. even if they did not indict. That's a lot just to get to that point. Now, the difference here, and what you have to remember, the difference between convening a federal grand jury to seek to prosecute someone is you need enough evidence to convict them beyond a reasonable doubt eventually. So you, as a prosecutor, you have a grand jury. Yeah, maybe you can get an indictment, but if you don't feel there's enough to go from indictment to conviction, ethically, you can't bring that case. And you wouldn't bring that case because you wouldn't want to lose. You wouldn't bring a loser. And it's unethical to bring a case where you don't feel like you have enough to prove it beyond a reasonable doubt. But that's to prove that someone else did something beyond a reasonable doubt, which is like percentages. Where do we put? I put it at like 97.5, 97.5. You got to get it to that level, 97.5. But to raise a reasonable doubt, which is what we're talking about here for third-party culprit, like it's just that little piece up there. You don't have to prove all of this. You just got to prove that little, there's the reasonable doubt. Just pluck it right there. That's the difference between what a defendant does and what a prosecution does. A defendant, when you're pointing at a third party, you're saying, yeah, ladies and gentlemen, do you have a reasonable doubt that maybe Higgins and Albert did this? Not that I proved it to you beyond a reasonable doubt, because I have no burden to do so. I have no burden to do anything. But is there there for you to have that much right there? That's all you need, is that little piece, reasonable doubt. Right there. There's not enough there on Brian Albert and Brian Higgins. And the judge says the proffer is barely sufficient. So she's saying that it's like that, like there's that much, right? Like there's that much. That's a reasonable doubt. They don't have that, but that's all they need. That's all you need to raise a reasonable doubt. However, to protect the defendant's right to a fair trial, and in recognition of the fact that the defendant has no burden to prove anything under our law, that's what I just said, the court will take some incremental approach as it did in the first trial. Okay. So the judge is holding them back as much as she can while trying to preserve any potential conviction. Meaning she doesn't want to bite off too much, but she wants to bite off as much as she thinks she can bite off from the defense without an appellate court looking at it and saying, oh, this judge was not fair. This defendant did not get a fair trial. And that's why she throws around the word that her goal is to protect the defendant's right to a fair trial. And she's recognizing they have no burden and they get a fair trial. So to get that fair trial, I'm going to do the same thing I did in the first trial. I'm doing an incremental approach to all of this. Defense counsel are ordered not to mention potential third-party culprits in opening statements. Last time they didn't mention names. Like that was the difference, right? They came out and said she was framed, but they didn't say who did it. I don't know what they do this time. Do they come out gunslinging? Do they come out guns a-slinging? Let me go to the next image. I think this is it. But counsel will be allowed to develop at trial if possible, and counsel may seek appropriate instruction if warranted after the evidence is concluded. Oh, I forgot to give you the footnote. That's where the good stuff is. Good stuff is always in the footnotes. Where's that footnote? Oi. Can you believe I did that? All right. I'm just going to read it here. What does footnote number 2 say? Where is it? The court notes that the defendant at the first trial, under an identical order, did not seek an instruction on third-party culprits. So that's a little zinger. Okay? That's the zinger. Let me get that for you. It was on the bottom of the last page. That's why I missed it. All right. 1 second. I'm just going to get that for you. back to you. Playing around on my computer. Let me give you that footnote. You got to get the footnote, Vinny. Come on. So this is a zinger at the defense. The court notes that the defendant at the first trial, under an identical incremental order, right, that we're talking about, did not seek an instruction on third-party culprits. She's saying, what are you guys doing? She's saying, like, and this is, again, for the appellate court, saying, listen, I made this decision because I sat here during the first trial, and these people are talking about a third-party culprit, and they didn't even seek an instruction at the end of the case. They didn't even try to. Why didn't they? Because I'm being reasonable, appellate court. That's basically what she's saying. Fascinating. I tell you, read the footnotes. This is the zinger. This is the little zinger. But again, everything that a judge writes in their, I go back to it here. Everything that a judge writes in their opinion is purposeful. It's there for a reason. And the reason is to uphold any conviction if the defendant is convicted when they appeal it. That's how judges you get judged by, like, everyone, right? Well, you get judged by the lawyers, like, how does she treat people, right? She gets judged by defendants. How do I get treated? She gets judged by juries. Did she treat us right? Did she tell us everything we needed to know? But ultimately, like, once you get around in the circles of, is this a good judge? Is this not a good judge? Right? If you ever get, perhaps you get an appointment to some other court. And I don't know how Massachusetts does it. I don't know if they do appointments for the Supreme Court there of Massachusetts, or for, if you want to, if she ever got appointed to the federal court, they'll look at, well, how many of her decisions, what percentage of them got overturned on appeal? And that's part of the basis of how they judge you, which is why you don't, even if you like, oh, I can't stand this litigant, I can't stand what they're doing. If you're going to rule against them, you're only going to rule against them as much as you believe that you can do without an appellate court tossing it back to you. And that's what's happening here. She doesn't want any of this in. She doesn't believe any of this should be in, but she knows she has to allow them the opportunity to develop it. Though the court may ultimately exclude the proposed third-party culprit evidence, letting them know, listen, this is not, don't misinterpret this ruling as saying it's automatically in, or counsel may abandon the theory. Oh yeah, you guys can just abandon it, kind of like you did last time, sort of. That does not mean that the defendant cannot offer the evidence to show inadequacy in the police investigation, provided that the proper foundation has been established. So here she gives them, this is the more classic approach that you see in many cases where people are absolutely like guilty. They attack the investigation saying that, well, you didn't investigate this person, you didn't investigate that person. And what you're saying is, well, ladies and gentlemen, they didn't look over here, meaning that, hey, they may have done it, but you're not saying they did it. You're saying we don't know if they did it because they were never investigated. That's what they're leaving open here. That's what she's leaving open, which is important and can be effective. All right, I got to check stuff from work. 1 second. Okay, got a note from work. Okay. I've got one. I think I have one more thing to show you. One more thing. That's not what I want to do. I have one more thing. Image. There's also a ruling, and this is on a whole different front, on the jurors. And basically, the identities of the jurors will be confidential. But the defense and prosecution will get the names of the jurors so they can check out their background and do a proper voir dire and investigation of the potential jurors in the case. So they will have the names, but they're not allowed to release them. So this is the reasoning why juror names will not be made public for an indefinite amount of time. This case has garnered significant and divisive attention in Massachusetts and around the country. Yeah, I know. And in a lot of the chats as well. Individuals associated with this case have been charged with intimidation, which charges remain pending. There they're talking about Turtle Boy. And we'll see how that turns out. That's a First Amendment case. That's like we're balancing the First Amendment to the Constitution against allegations of intimidation. We'll see how that turns out. I don't think prosecutors will be successful there at all. At least one deliberating juror from the first trial submitted an affidavit to the court detailing reasonable fear for the safety of their families should the list of jurors be made available to the public. Why? I don't know. Like, you guys didn't even make a decision. Well, you did, but you didn't, right? You made a decision on 1 and 3, but it hasn't been recognized. But that's just like, to me, that is just fetched out of air. Like, no one threatened any jurors. No one's going after any jurors' families. I guess not happening. This is not a mob trial, okay? Like a mob trial, like there were actual cases involving John Gotti where they got to jurors, right? And if you're a juror on like a mob or a gang case, there is fear. She's a college professor. She's not having anybody whacked. But I get it, right? You don't sign up for jury duty necessarily. Is that a reasonable fear? I don't think so. This court concludes that the fear expressed by the juror, coupled with the inordinate amount of public attention to this trial and its outcome, is good cause to impound the clerk's list of jurors for the Norfolk County Courthouse for the duration of the impoundment. I have no problem with it, by the way. It's a public trial, but we are taking citizens away from their lives, away from their homes, away from their families, and injecting them here. I am a pro-juror guy, right? I'm the guy who believes we need to give jurors more information, more evidence, involve them in the process so they understand a little bit better what's going on. And on the other hand, I believe they also deserve some level of reasonable anonymity and protection during the course of the trial. Now, after the trial, it's hard because it's a public trial. I mean, at some point, the names will be unsealed at some point. But at this point, like, there's no reason. We don't need to. The public doesn't need to know the names. Members of the media don't need to know the names. There's no value to that. They are showing up in court in person. There's no secretive things happening here. So, further, this court concludes that good cause exists to impound the list until at least the conclusion of the trial. And that's where I think everyone's going to have a problem, at least the conclusion of the trial. What does that mean? That's a little vague. The end of the trial plus whatever. 6 months, fine. It doesn't bother me. If a juror wants to speak, they're allowed to come forward, and they did that in the first trial. I'm not one for chasing down jurors, like chasing them down. Ones that they should know. They know that they can come forward and they can speak if they want. I've had trials in Massachusetts where the jury chose to stay, and we interviewed them in the courtroom right after the trial. It has happened. Like, it doesn't happen a lot anymore, but it's happened. So again, I'm protective of the jurors. I think the way judges are. Oh, okay. So it can be done, but we don't need to like chase them down, rat them out, protest in front of their house. That's absurd. That undermines our system, right? If they want to, they serve in the jury. We see their faces. They speak as one at the end of the case, and then they go on their way. If they want to talk afterwards, they're allowed to talk. and I'll talk to any juror afterwards. But I will not, excuse me, juror number 6, why did you do this? And throw a microphone in front of them. No, not going to do that. And by the same token, in a case like this, the public should not, be tracking down these jurors. If there's something about the juror that comes up post-trial or during the trial about a juror engaging in some misconduct, well, that's up to the lawyers and their investigators to figure out whether it's the prosecution or defense. And it's up to the court to get to the bottom of it. It's not up to the public and the media. All right. Those are my thoughts on that. Oh, by the way, folks, you may notice I'm wearing this lovely piece of merch. And it's all available at my merch shop.
Hey everybody, I've got something for your body. You can wear it by yourself or with Frankie Valli. It's true crime merch from Vinnie Originale. It's true crime merch. It's true crime merch. It's true crime merch from Vinnie Originale. From Vinnie Originale.
All right, there's the link. I think one of our mods, Ashley Bouchard, is posting it for us. The link. It is legit. It is real. It's the Vinnie Originale True Crime Merch Shop. And there's the link. You can't click on this. I don't know how to do that. At some point, I'll learn how to do that. But I think in the chats, you can find a link if you want some awesome true crime merch that we have from the Vinnie Originale shop. All right. All right. Before I run out of time, you got to get to your comments. Now I'm scrolling from the beginning, so I'm way behind already. I'm an hour behind, so I'll never catch up. So I'm going to zoom past a bunch of these. But don't forget, Gen X is here, along with Ashley Bouchard and the rest of the Mod Squad.
Order in the chat. Order in the chat. Don't dare attack, we've got order in this chat. The Mod Squad is on the job, helping us to keep it clean. The Mod Squad is on the job, always so nice and never mean.
All right, and especially in this case, the Mod Squad worked so hard because all of you are so passionate. But we can disagree without being disagreeable, right? I'll say some things you don't agree with. Yeah, that's okay. You'll say some things I disagree with. Maybe we'll agree on some things, but that's the nature of our system of justice. There's at least two sides to every story. And in this one, there may be 10 sides to this story. But Gen X, Frankie Figs, Jennifer Sube, Ashley Bouchard, in the middle of it with you all there. Thank you so much for the work you guys do. It's appreciated. All right, we're going to get to some comments now. I'm going to roll through these, see who's around, who's doing what, who's zooming who. Okay, Brenda is seeing bias over on YouTube. The bias is being shown for all to see. Free Karen Reed. So she's part of the Karen Reed camp. Let's see who else we got. T Lemon saying it's Paul Newman's son, Vinny. Well, I'm actually Nick and Marion's son, and yeah, they both had blue eyes as well. So that's where I got them from. But I know what you're saying, T Lemon. Where is that? Is that in the desert or is that in the dunes of the Cape? Where are you? Are you having a pina colada in the dunes of the Cape? All right. Oh boy. One more song, ladies and gentlemen.
To get up,
Free McSpunky.
it's time
Do
to
we ever
get
pay for
funky.
McSpunky?
It's time for us to smile, 'cause here comes McSpunky.
All right. Thank you, McSpunky. Now, there's someone who knows how to get along with everyone. Thank you, McSpunky. Kim Ross Poteet on Facebook What is new about Karen Reed today? It's something every single day. It is everything every single day. Today, there were a bunch of rulings that the judge came down on. I thought the biggest one was, we're going to talk about it all tonight on my show, Closing Arguments with Vinnie Politan, 8 o'clock tonight. I thought the biggest one, though, was on the third-party culpability, and we went through all of that. Can Karen Reed point the finger, and who can she point the finger at? Maybe Brian Higgins, maybe Brian Albert. That's where it's going to go. But they have to develop the evidence for it. So that's the latest today. There is something every day, but tomorrow is jury selection. How about that? Jury selection, which is technically the beginning of the trial. Trial begins with jury selection, right? That's day one of the trial. But I really call day one of the trial those opening statements. The opening statement. To me, that's when it really begins. But this part is absolutely part of the trial, and many would argue the most important part of the trial is choosing and excluding the people who will hear the evidence in this case and make the decision. It is so important. And don't forget the huge advantage the defense has this time around. One of the jurors from the first trial is on the defense team in the second trial. She's a lawyer. She was an alternate juror. But if she hadn't been an alternate, if she was like a regular juror, she may have been able to convince the rest of them to just send Karen Reed home, because she does not believe this case should have been brought. All right, I'm gonna start scrolling fast now, just to kind of get a little more, because it's tough when you do the comments from way back when, last hour. Then I'll never catch up. So I'm just gonna scroll randomly. And when I see something interesting, I'll put it up here. So here it is. 5 Cats Television watching on the Court TV YouTube. Vinny is sending my Court TV kittens to sleep while they have their supper. It's good to know. It's good to know. I hope it's not because they're bored. Here's Kathy Marie. Vinny, are you coming back to Dedham? Yes, those are the plans. I am tentatively looking at the week after. None of this is official. None of this is official. I'm looking at like maybe the second week of May. I want to get there sort of on the front end at some point. We don't know exactly when it's going to start yet, so we can't plan like for opening day, but probably at some point in May. And we're going to do the show live from Dedham, and all y'all who are out there, you need to show up. You need to show up. Be part of the studio audience. We will pump that up when we get there. But thank you so much. We'll be coming back. This is interesting. I just had to put this up. Stacey Ann Rovini. Hey, Rovini, che cosa? Iris, why you keep going back and forth between guilty and not? You sound crazy. Well, I mean, not really in this case, right? I mean, the jury could not come to unanimous decision on that second count. So I could see how people are like that. This is one of those cases. Like maybe your gut is telling you one thing, but like you're looking at the evidence and it's something else, right? Like my gut from the beginning of this was like, oh, and the first headline, drinking, driving accident. Okay, I get it. I've seen this before. And then we learned all this other stuff. And then they changed the charges and upgraded them. I'm like, what's going on here? I thought this was, drinking, driving accident, and it's all of a sudden it's something else, something completely different from both sides, which makes it really strange. And then in the end, the jury ended up where we started, which was fascinating to me, that they were debating what we were debating when the story first broke, before the upgraded charges and before the how's long to die in the cold happened. But what was the evidence in the first case? To me, the experts that testified about the wounds and John O'Keefe's death, like prosecution did not get it done. They did not get it done beyond a reasonable doubt with their expert, and they needed to with their expert because they didn't have an eyewitness. And they didn't get it done. And the experts, I thought from the defense, who some call defense experts, they were the ones hired by the feds, came to a much more science-based conclusion. We'll see what they do in the second case. I think the prosecution is going to up their game when it comes to experts. They need to, because it was more than underwhelming. It was one of the few cases where I've seen a battle of the experts, and in my eyes, one side clearly won. All right, people asking me to admit things. Kim Queen on Facebook. Vinny, you have to admit timeline with Colin Albert is way off. It's way confusing. The timeline is way, like, things don't, it's not, to me, it doesn't add up. Not, to me, there's more than one interpretation of Colin Albert. But the judge ruled, so he's not going to play a major role in all of this. He's just not. And if that's a basis for an appeal, if again, big if she's convicted, we'll see. All right. We've got Takeisha Baines with a super sticker. Thank you, Takeisha. Now, I think it's Takeisha, but I see the Y and I want to say Ty, right? Like, if we were friends, I'd probably call you Ty for short, or Takeisha, or Keisha, or Shia. A lot of ways you could go with that name. Beautiful name, beautiful picture. Thank you so much. Carrie Vance, Facebook, are there cameras? Yes. Court TV cameras in the courtroom. You're going to see the whole thing, folks. You're going to see the whole thing. So we're good to go. Tara Lee B. Get Colin's phone records. Metadata. Not going to get it. But I get what you're saying. And that's part of the investigation. This is what I was saying. The disadvantage for the defense is that if prosecutors wanted that information, they'd be able to get it. They would have. Like in the initial investigation, said, oh, we're getting the records of all the people who were there at the party because of this. They would have gone to a judge. Judge would have signed a warrant. They would have got it all. But then you go after the fact, someone else has been charged, defense, they don't have the same opportunity. It's not an even playing field. Like, you've got such an uphill battle with the third party culprit. You're going uphill. But again, you only need to prove this much. But that's the disadvantage. That's the inherent disadvantage. Some would say the inherent unfairness. But let's see. Let's keep rolling. I'm only 40 minutes behind right now. Here's Mike. Vinny shows favoritism to Nick Rocco over Kevin Lenahan. Don't ask Nick Rocco that, because he was the other night we had some miscommunication and Kevin was on without Nick Rocco. So there's no favoritism. I give everyone the opportunity to speak their piece. I would ask Kevin if he feels like he's being disfavored. But I don't know. Kind of ask the same questions to both of them. But everyone's entitled to their opinion, Mike. I'm just saying from my perspective. We have them on together to create that balance. The same way we try to balance the attorneys. But I do not tell anyone what to say ever on my shows. I don't say, you take this side, you take that side. We may ask them ahead of time, how do you see this? Just to try to keep the balance there, especially in a case like this. But thank you, Mike, for watching. Appreciate it. That's a great picture. Are those horns? Oh, yeah, I got to show that again. Are those horns on, or is that an optical illusion? Is that a steer? Would you call that a steer? I'm not sure. All right. So the big thing with Colin Albert, the reason why and this is from Justin Tharp. Thanks, Justin. They got him on video threatening other people to fight. Colin was at 34 Fairview. No reason to hide that fact, but they did. So lack of evidence is evidence. See, the defense saw this in a couple of ways. The Haas long to die also, in the extraction that was provided by the prosecution, it didn't exist. They had to get that through their own expert. So they felt like they were hiding that. What else are they hiding? That's the perspective and the point of view of Karen Reed and her defense, is that they were not providing all the evidence. They were being deceptive in the investigation and in providing information to the defense, which they are obligated to do. And that's really the point where all this sort of took off, right? It started with the Haslong, the extraction. The prosecution didn't provide it. Why wouldn't you provide us with that information? We had to get it from our own guy. What are you trying to pull here? And that really began the defense looking at the prosecution, the investigation, the state police, the DA's office much more skeptically. It wasn't born out of thin air. It was born out of actual things that happened that should not have happened. And this is part of it. Was Colin Albert. It was not revealed that he was there when he was there that night. I guess the big question for the judge is at what point was he there? What point did he leave? And the judge is saying not there at time. Gringa, thank you so much, Gringa. Doris and I want to know, can defense argue a theory without naming names? That's kind of what they did last time. Remember the opening statement? Framed. Well, who framed? You'll hear the evidence, ladies and gentlemen. And that's the way they did it. Will they do it the same way in the second trial? Maybe. What can you say at the end? Can you say she was framed without saying who framed her? Saying somebody in the house? Maybe, maybe not. There may be a need to argue third-party culprit without naming a third party is what you're saying. So is it a third-party culprit if you're not naming a third party? Well, it isn't, because you're not pointing the finger at a specific person, but there is a finite number of people inside that home. So arguably you are pointing the finger at like someone in that home of, however many people. Was it 8 people, 9 people, 12 people, 14 people, 6 people, 4 people? Like there's a finite number of people there. So prosecutors would probably object. If you started to do that, you would probably have to clear that with the court. There'd probably be some discussion about that, and it might be at sidebar. It could be an open court about what does the defense plan on arguing in the closing arguments? Are they going to point the finger at someone? But as you saw in all this pretrial hearings, if it's going to be a specific person, they've got to develop the evidence. Now, if it's just like, I think the best they can do is say, we don't know what happened. Something happened there, but we don't know what happened. And what I would argue, I would say exactly what I've been saying here if I was the defense. If the judge doesn't allow third-party culprits, say, listen, ladies and gentlemen, I don't know what happened inside that home. You don't know what happened inside that home. And you know why we don't know? Because they never investigated the home. They never investigated the people inside that home. And as a result, we don't know what happened. What we do know, and then you get into Karen Reed did not do it, and you make all your arguments as to why you believe she did not do it. That's kind of, I think, the way that you would play it. But if you got specific, I think you would get a little more specific about what happened inside the home, based upon the injuries, based upon the timeline, based upon the butt dials, all of that. You put those pieces together. Don't forget they have that video going from the basement out the, what do we call it? We called it a latch. We called it I forgot what we called it in the last live stream. Short-term memory. And then out the backyard, right to the front yard through the gate. You sort of can. But you can't argue exactly what happened to him. I think what you have to say is, we don't know what happened to him. Nudge, nudge, wink, wink. Somebody in there, did it. And you know who they are. All right, here's Mike, who does not like Alan Jackson. Oh, this is Mike again. Say Mike. Steer Mike. Your posts keep catching my eye, Mike. It must be the steer. Sleaziest human since Bill Clinton. That's interesting. The reason I chose this, I want to give you a little of the background of Alan Jackson. Alan Jackson prosecuted Wall of Sound, Phil Spector, Phil Spector. He was the prosecutor in that case years ago on Court TV. He was the sharp young prosecutor. He ran to be DA in Los Angeles and lost to George Gascon, the guy who wanted to set the Menendez brothers free. And anyhow, he lost that. So he was a prosecutor, wanted to be the prosecutor, lost the election, and ended up becoming a defense attorney because that's where your expertise is. And got this case, as you saw probably in the documentary, and we were covering the case. He represented Kevin Spacey in Massachusetts and his Cape Cod. That was a ridiculous case, by the way. But he got everything went away. And that was one of the reasons he was called for this Massachusetts case. He's a California lawyer. Yeah, he tries cases around the country. But that's his background. And he had a stellar reputation for years. And here I think, part of the fallout of this case is that everyone associated with it, even people who stream about it, in the eyes of some people, will be labeled as certain things, and everyone's entitled to their opinions. And you could think, I'm just telling you that historically, Alan Jackson, as I know him from covering high profile cases on Court TV through the years, and his reputation and his history out in Los Angeles. But we'll see. I think everyone gets damaged by this a little bit, and everyone gets a little more notoriety from this as well. And a lot is going to depend upon the result. A lot. All right, here's Susan. Hello, Susan. Thank you so much. Thank you for explaining, Vinny. That's what I'm here for. That's what I'm here for, Susan. Thank you for watching and supporting. All right, where am I? I'm only 46 minutes behind. 46 minutes behind. This is like being at the DMV, right? All right, Nicole, 1 of 1. Appreciate your explanations, and I appreciate your support, your hearts, and great little. What I'm trying to figure out was, there's a photo behind your photo. I couldn't figure out what that was, but that's your face behind your face. Cool. All right. Maria Gutierrez. The judge needs to be fair with both the state and defense. In the first trial, in my opinion, the judge was biased. A lot of people shared that. Now there's bias, and then there's crossing the line bias, where you are doing things that appellate courts may have trouble with. And so far, I don't believe she's crossed that line. But the rulings have leaned one way. It's like that in every case, in front of every judge. Every judge is a human, sees things the way they see it. And sometimes things go one way. Like every judge has a sort of a reputation inside the courthouse. And when I worked in the courthouse, I knew the ones that were going to rule for me. I knew the ones that were more likely to rule against me. And then there were others who were like, depends upon the day and the issue. Okay, I'm seeing some good back and forth going on here. See some good back and forth. All right, this is Brian Jr.'s Frozen Donuts. I'm just fascinated by that name. Vinny, you got to get Bettero on here. Pump those numbers up, baby. I don't know what that means. But the only number I'm concerned with is the one at the end of the show. And you know what I'm talking about. The most important number in my life. The old blood sugar, which if I'm eating your frozen donuts is gonna go way up, Brian Jr. Thanks so much. Oh, it's hilarious. All right. I'm gonna run out of time here shortly. All right. Court TV reminded everyone, keep it classy, chat, or you get put on the naughty step. Hilarious. And don't forget, if you join the Court TV YouTube channel, they have a membership program, amazing membership program. Scott 5, Colin Albert not allowed, just joining. Correct. He may still be a witness, but they won't be able to point the finger at him. They will not be able to point the finger at him. Mhm. Let's see. All right. I'm scrolling. I'm trying to catch up. I'm only a half hour behind now. Mm. Rosie, straight and to the point. Karen is factually innocent. What you want to do is send all your information to the defense because you are the perfect defense juror. They want 12 Rosies. Thank you, Rosie. Mm-hmm. Mm-hmm. Let's see. All right. I'm getting closer. I'm getting closer. Some great handles, by the way. All right. See a little back and forth, a little back and forth. Michelle L. R. Allen was denied a third-party defense. Richard Allen in the Delphi case. Yes. And that case, not only was there a potential third party, there were members of the task force who were ready to arrest somebody else. They wanted to put cuffs on somebody else. So it happens. All right. All right. This is an interesting one. I'd like to address this really quickly. And this is from our friend Mike. Again, Mike. I keep going to Mike. Mike, you're very provocative. Vinnie thinks Turtle Boy is a journalist. Wow. That's a First Amendment case. Now, the First Amendment does not apply to journalists. It applies to everyone. To everyone, whether you are a blogger, whether you are a citizen, whether you are a mechanic, whether you are a politician, whoever you are, the First Amendment, any American, the First Amendment applies to you and your freedom of expression. So don't confuse that First Amendment is only for members of the media or for journalists. No, not even close. First Amendment is for all of us. It's for all of us. And I am as close to a First Amendment absolutionist as you can get. Is that a word? I made it up. My bad. All right. Now, Karen Freet Eckert, she's guilty. 2 words, exclamation point. You need to send your information to the prosecution. You're the perfect prosecution juror in this jury selection process. Thank you for opining. Miss B Heaven, it's 22:22. That's a half hour ago here in the UK. Good night, chat. Well, she went to bed already, but we will say a good night. All right. April Diaz. It was a dentist day for April Diaz.
Thank you, April Diaz. Have a great day today. Thank you, April Diaz. We appreciate everything you say. We all know she's a great fan, and we know the kind words she has. We always love to hear from you. Thank you, April Diaz.
Big thank you to April Diaz. Another doctor day for April.
Thank you, April Diaz.
Thank you, April. Great to hear from you. Hope everything was perfect at your appointment. All right. I am quickly scrolling through because I am almost literally out of time. But I know there's a few comments here. I've seen some comments that I need to get to. I just got to get to them. I'm still 20 minutes behind, scrolling fast. Susan, Vinny, when will the Sandra Birchmar trial take place? I don't know, but it's federal. It's federal trial. You're not going to see it. You got to go to the courthouse if you want to see it. The feds don't let us in. I don't have a trial date for that in front of me. But again, federal, big problem for cameras. The Supreme Court of the United States, Chief Justice John Roberts, he's the one you need to write to, does not permit cameras. And it's his decision alone. He could change it like that. He could let cameras into federal courtrooms or at least give the judges the discretion. But it has not been granted. Big disappointment with Justice Roberts. Very disappointed in him. Char Redmond. Hi, Vinny from Aussie. Love your analysis on the cases. Oh, fantastic, Char. Make sure you watch Closing Arguments tonight. I don't know if you can see it down there in Australia, but we've got a story out of Australia tonight. That's all I'm saying. A story out of Australia tonight on Closing Arguments. That's all I can say. All right. I see some people calling me names, which is wonderful. This is the best, though. Johnny Knoxville. Vinny is a legend. Thank you, Johnny. There were some not so nice ones. But I'll keep that one up for just a bit. I just want to scroll because one of the rules I have is before I run out of time, I want to make sure I get to all the supers. Michelle L. Proctor was thanked for leaving Colin's name out of the reports. His parents said they were going to give MP a gift for that. See, that's problematic, right? That's like all of this stuff, whether you believe in it or don't believe in it, it wasn't born out of thin air. There was a basis for all of this, which is why, with a basis, I think it should be allowed. Okay. Imagine what Napoleon Babe Jean, Karen Reed's late grandfather, would think of his granddaughter framing cops since he was a Fall River career cop, says Paula. I didn't know that there was a law enforcement in the was that grandfather or great grandfather? Okay. Interesting. So I guess her mother's father was a Fall River police officer. Thank you, Paula. Thank you for the info. Did not know that. Kathy Guidry, how do they know that one of the girls riding with Kaylee that night out looking for John didn't use her phone to Google how's long to? This is that night. I'm trying to figure out. So the how's long, right, is McCabe, who's with her in the morning. They're saying she did it. She Googled it in the morning after Karen Reed asked her to do it. The defense is saying she did it at 2:30 in the morning after some butt dial action and whatever happened from their perspective to John O'Keefe, and he was placed on the front yard. So they're trying to figure out how long it would take. It's either before the fact or after the fact is the question. And that'll be another battle of the experts inside the courtroom during this trial. That battle, I think, will be a lot closer than the battle of the accident reconstruction experts, which wasn't even close last time. Chewy the foodie, love you. I feel you would make a great judge. No, there's only one Politan who was a great judge, and that was my father, who was a federal judge in New Jersey. Legendary federal judge in New Jersey. As a matter of fact, a couple of weeks ago, I was back in New Jersey, and I went down to the federal courthouse to take a look at his portrait, which is up on the walls in one of the courtrooms in the federal courthouse in New Jersey. All right. 1 second. Let me see if I can do this. Nope. I'm going to go here. All right. We are so close to being out of time that we are really out of time because I have to get to the studio. I've got to get to the studio. but I will do this. Banging a gavel for Love My Grands has become a YouTube member over on the Court TV YouTube channel. Congratulations. Welcome. Great to have you aboard. Great to have you aboard. Okay. Boom. Vinny, if you were a juror on the first trial, what would you have done? Well, I would have written a book. No. What would I have done? This is what I said after that trial. I said, number one, count 1 and count 3, gone. I would have been debating count 2 with the rest of them. And honestly, I would have been the type of juror that I was in my civil case, where I have an open mind to what my fellow jurors have to say. But I did not believe, I thought the Battle of the Experts was won by the defense. I don't believe a conspiracy was proven. But I don't think the prosecution carried their burden, right? I don't believe like they carried their burden, and they have the burden. I know, I was a prosecutor, used to have to carry that burden. They needed a better expert to explain how the tail light could have been broken, the injuries on John O'Keefe, and their experts were not great. All right. Got a couple more I got to get to. Nick TTT. Why are so many Court T hosts so anti-Karen and pro-prosecution to a fault? You know who I speak of. LOL. Do you ever discuss the case with other hosts? Thanks, Vinny. Love the show on all formats. We always discuss the stuff when we get together. I come in at night though, like, because I'm not in the office all day, so I don't see everyone that often. I'll see Michael Ayala the most because his show is just before mine. But yeah, we debate the evidence. We debate the things. We agree. We disagree. But I think we agree more than we disagree for the most part. Most of us, but not all of us. I feel like there's some who in most cases are a lot quicker to reasonable doubt than I am, right? I'm a former prosecutor. I tell everybody, like, that's who I am. So we do discuss the stuff. Johnny Knoxville, keep up the great work, Vinny. You have many fans on the interwebs. Thank you so much. All right. I'm doing a super duper fast scroll, and I am okay. I got all the supers in. Thank you, everyone. So, all right, we're going to do it because it's the last day of the month, right? It's the last day of this quarter. Each quarter, we have a winner who can guess my blood sugar the most times correctly. We have a bunch of people who have guessed it correctly once this quarter, but only one has more than one. So as long as she holds on today, she will be the winner. But it is that time, folks, and I feel good today. That's all I'm saying. I feel good.
Here's a type 1. Here's type 1. His pancreas is on first. He has diabetes, type 1 juvenile diabetes. And so it's time to guess, is more or less. What's his blood sugar? What's Vinny's blood sugar?
Elise!
Under 70, he gets life's head. Under 60, all the alarms start ringing. Over 180, he starts to get lethargic. But when it's 90,
all right, Elise. I don't know if you've won before, Elise. Ashley Bouchard is our official scorekeeper on this. So she's got to send me a text. Has Elise won before? Or can we announce this quarter's winner? Or are we going to overtime? All right. I'm waiting for a text from Ashley. If she's still with us, she may have had to sign. Oh, she's on. She's here. Quickly check. Is Elise a one-time winner? First time? Dun, 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 dun. Dun, dun, dun. We're going to see. We're going to see. Has Elise won before? Nope. All right. So, ladies and gentlemen, she didn't guess correctly first today, but Doris is our quarterly winner. And Doris, what we're going to do is in a future live stream, we're going to have a little game where you are going to pick your prize. Okay. It's going to be a very special thing. We don't have time for it today, though, because I'm already 10 minutes overtime here. But Doris is our quarterly winner. We do it every quarter. And we'll talk about the great prize that you're going to win coming up. But that's it for today. Big thank you, of course, to the Mod Squad, to everyone who watched, all the super chats. Amazing, amazing, amazing. And as you see, folks, I don't mind if you disagree with me. I really, really don't. I think it's part of what we're doing here is having a nice, vigorous debate. Change my mind, or I'll change your mind, or we'll talk to each other. We do the same thing that the jury does inside the jury room. That's who we are. We are the 13th juror. So thanks for watching. Great job, mods. Great job in the chat. Great job by all the super chats. And that's it, folks. 8 o'clock tonight. And a big thank you to Court TV for the simulcast. Make sure you subscribe. Make sure you subscribe, subscribe, share, subscribe, share. And watch me tonight, 8 o'clock, closing arguments, 9 o'clock, Vinnie Politan investigates. We're going to do the Idaho 4 tonight. Got some interesting angles on that. Of course, we're going to talk about Karen Reed. And I've got a story out of Australia tonight. And Al will be with us from the Tangents. Will be on the show tonight at 8. So have a great night. And as always, folks, please don't forget to hug the kids.
Say goodbye. Thank you for watching Vinnie Live. We'll be back, but I don't know when. We hope that you will watch again. Vinnie Live. It's Vinnie Live. Whoa, it's Vinnie Live. To our awesome mods. Thank you for those super chats. Please hit the like and do subscribe. Let's do it again on Vinnie Live. Now before you go, just one more thing. Please post below, say anything. Before you go, just one more thing. Please post below, say anything.